This is Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund fellow Richard Reinsch. Our web address is libertylawsite.org, where you can subscribe, comment, find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org. Today we are talking with Professor Michael Rappaport, a regular blogger at Law and Liberty, about the Mueller investigation and the general constitutional questions surrounding policing the executive branch. Michael Rappaport is the Darling Foundation Professor at the University of San Diego School of Law, where he also serves as the director of the Center for the Study of Constitutional Originalism. He is author, most recently, or co-author of the book Originalism and the Good Constitution, along with John McGinnis. He is published in leading law reviews, Yale, Virginia, Penn, Georgetown, among others. Mike, glad to have you on the program.
Happy to be here, Richard.
So, Mike, you've published on this issue of policing the executive. You've written a lot at Law and Liberty on this subject. So, maybe here at the beginning, before we get into more substantive constitutional questions on this issue, your sense of the Mueller investigation, what's happened to this point, and signs, evidence, portents of where you think it might be headed.
Well, I think we're still pretty much in early days of the Mueller investigation. I mean, it's hard to know, but because we don't know what the future is going to be. Yeah. But if one looks at these kind of special counsel, independent counsel investigations, they have often gone on for very long periods. The jurisdiction for the special counsel in this case is extremely broad, so he can be looking into any number of different things. And of course, once they start looking into something, they can easily find something else that's closely or maybe not closely related to the original purpose of the investigation and have that expanded. He's got a large staff, 15 lawyers, and counting. So it's a little hard to say. Not a lot, has really happened. But I think we could be in early days on this, and I think this could go on for a long time. Obviously, it's impossible to know for sure.
I wanted to read Rod Rosenstein's order appointing the special counsel, just to sort of reiterate how broad Mueller's authority is. The special counsel is authorized to conduct the investigation regarding any links and or coordination between the Russian government and individuals associated with the campaign of President Donald Trump, and any matters that arose or may arise directly from the investigation. That's a pretty broad gambit of things that obviously Mueller could be looking at. What are the constraints that he faces, though, in his own investigation? Budgetary constraints, manpower constraints. I mean, you mentioned 15 lawyers. That's a small law firm. You can do a lot with 15 lawyers. Throw in a few paralegals, some office assistants, and widespread access to the information he needs as a government appointed official. He could do a lot of damage, speaking.
Yes, he can. There's a budget provided by the Department of Justice, but that doesn't seem to be too constraining. And more than anything else, I think he has not only these resources, which is, as I say, a very large amount to begin with, but once he starts digging, and if he comes in and says, I have some evidence here of wrongdoing, but I need additional resources, it becomes very difficult for the Department of Justice to say, no, we're not going to give you more resources here in order to do this. So he's in a position where it becomes very difficult for the department to cut him back, even if they were so inclined to do so. So I don't think there are very significant constraints. One constraint that independent counsels have faced in the past was the popularity and to what extent how they were viewed in the public. So President Bill Clinton made it his strategy to kind of attack the Ken Starr administration, the Ken Starr investigation, and they were very successful in that. Ken Starr was pretty unpopular by the time of the end of the investigation, and so there are political checks, I suppose, in the sense that the public matters, but as a legal and in certain ways practical matter, not very much.
Yeah, no, Lanny Davis once likened, fighting with Ken Starr as the equivalent of hitting a low-hanging softball, sort of coming right in across the plate. I mean, this just wasn't a fair contest.
And part of that,
decimate him. Part of that, Ken Starr, as you and I were, discussing offline, as these investigations are wont to do, took things too far. It seems to most people he took it too far, and yet Bill Clinton also lied under oath. So what are you going to do?
Yeah. The only point I was going to say also is that it becomes a little difficult for the independent counsel to engage in a political fight with the president. Right. So one of the things the independent counsel or special counsel has going for them is they're supposed to be impartial. They're supposed to be non-political. That's their sort of power. And if the president starts attacking them in the political arena, it becomes very difficult for them to respond. And that's part of the problem that Ken Starr faced. He could come back out and say, Bill Clinton did the following things, and this is inappropriate, and so on. But there was limits in what he could say, because if he was seen to be too political, that would undermine his authority.
Yeah, it's interesting here as well. Mueller, obviously not Ken Starr. You see the way Mueller is covered in the press, very adulatory, straight shooter, a man beyond reproach, beyond questioning, and he seems to have really all of the capital. And then we have in President Trump, I think a very weak president, one of the weakest presidents we've seen in a very long time. And so those power dynamics are interesting. It's interesting, we were talking about... Go ahead.
No, it's the press is very important in these things. So people forget that Ken Starr, when he was appointed, had the reputation of being a very moderate Republican. He was someone who had been considered or was in the race for the Supreme Court, but it was always thought that maybe he was too
that's interesting.
Too moderate, not conservative enough. And in certain ways, he had a similar reputation. I mean, the differences, obviously, to Robert Mueller, who's also thought to be a kind of establishment, at least was a Republican in 2001. We don't know, but let's assume that he's still a Republican. And so both of these people are sort of moderates, let's say, or at least have the appearance of that. And then the question is, what then happens? Right now, Robert Mueller has had great press, and comes across a certain way. Very quickly, as Ken Starr was investigating the Clintons, the press and the presidential attacks came, and so he came to be viewed as some kind of arch conservative. And so, the press really matters in this area, as it does in a lot of areas.
Yeah, I was thinking also here that the 15 lawyers Mueller has hired, heavy hitters. Thinking about the constraints he faces, he's got some of the best talent in the country as people who have participated in prosecutions and also, I imagine, defended and high-level white-collar crime. So he's got a good cast around him in the course of making this investigation. And they have a broad charge, but also a singular-minded focus on it.
Right. He certainly has legal talent, if you will. I think one misstep he's engaged in, and it's a little, it's kind of interesting, is that he's hired people who seem to be all Democrats.
Yeah.
We don't know for sure, but we do know that from the campaign contributions, I forget exactly the number, but about 7 of them have given campaign contributions to Democrats. really no campaign contributions to Republicans at all. And I think ultimately that's a bit of a misstep from his perspective, because he can now be viewed as leading a partisan investigation. If he hires some people who are sort of known Republicans, people who Republicans outside the investigation could say, so-and-so, I trust this person. He's got a mixed bunch of people there. There'd be a lot more credibility. That doesn't mean that's going to stop him in the courts. It doesn't mean he's going to get bad press. But I'm surprised by the fact that he hasn't hired people on the other side. I saw one piece saying that he has a bit of a political tin ear. I'm not quite sure if that's right, but it is an interesting aspect that the staff appears to be so one-sided, and it's a cause for concern in my view, because I think we ought to have diversity, political diversity, bipartisanship involved in a special counsel investigation. And I think it should be a bit of a concern for him, because
he's making his job
reduces
harder.
Not in every quarter the reputation of the investigation.
Yeah. So moving into maybe more substantive constitutional discussion here, independent counsel versus independent counsel versus special counsel, independent prosecutor versus special counsel. I mean, what's the difference here? I mean, this was something that I just had to go back and think about between, say, a Lawrence Walsh or a Ken Starr versus Mueller. How did this come about? And are there any substantive differences between what Mueller can do and the authority he has, versus what, say, Lawrence Walsh or other independent prosecutors had in the 70s and 80s and 90s?
Right. So there's a bit of a history here, but basically until we got to the late 70s, the government occasionally employed this special counsel process, where and the way that works now, there's a Department of Justice regulation, so it's an executive branch regulation which says we will give independence to the special counsel, and the special counsel can do an investigation within the area of their jurisdiction. So it's not. So the regulation, first of all, comes from the executive branch, and it's not very constraining of the executive branch. So it's basically an opportunity for the executive branch to appoint someone in individual cases where they believe that it would be appropriate. Contrast that with the independent counsel statute, which came after Watergate and after Richard Nixon fired the special prosecutor in that case, Archibald Cox. Was a statute passed by Congress, set up in such a way so that presidents would be required under very broad circumstances to appoint or to seek the appointment of an independent counsel. The independent counsel was actually appointed by a court, and then that independent counsel pretty much was independent, and was independent under the statute. And if the Attorney General were to seek to fire the independent counsel, that would go to court, and there would be judicial review of that. Not something that the special counsel regulations anticipate, and of course we've seen now some statute or some proposed statutes out there seeking to do exactly that, which is to have judicial review of any possible firing of the special counsel.
Go ahead.
No, that's
my understanding. I mean, just thinking about Morrison versus Olson, which is the constitutional authority on this subject, there could still be an independent counsel. I mean, there is nothing that says. I mean, in fact, it was affirmed 8-1 under Morrison versus Olson. But now we have the special counsel. There's constant discussion of Trump being able to fire Mueller if he wants to, or to direct the Attorney General to fire him if he wants to. And this is somehow seen as corrupt. Noah Feldman, professor at Harvard Law School, has said this whole discussion of Mueller being fired on a moment's notice indicates the structural weakness of our Constitution with regard to policing the executive. So the independent counsel was a sturdier way to do it. Why did we move away from it? It wasn't necessarily out of a constitutional change, doctrinal change, was it?
Well, there's two aspects of that question that I'd like to talk to. So the first one is people are often very worried about the special counsel being fired, since they can be. And that was the principal justification given for the independent counsel statute in the first place, because Archibald Cox had been fired. And now you hear talk endlessly about the possibility that Robert Mueller will be fired. But I actually think, although I've become much more sympathetic to some kind of independent counsel matter, although I think reform, even though I think it has a lot of problems with it, I don't worry about that.
Okay.
Because people always leave the other part of the story out. What happened? Archibald Cox was fired, and Richard Nixon was forced to name Jaworski as a special counsel to replace him very quickly. Right? You can't get away politically with firing a special counsel. And if Trump were to fire Robert Mueller, I don't know if he would be impeached. But it would be a very bad thing for the Trump administration. And that's not something I worry about. Once a special counsel has been appointed, being fired. So in fact, I think there's a good argument for allowing the executive branch to fire the person, even though I don't think that power will be exercised very much.
So you bring up a separation of powers point, which is the competing branches, institutional branches will, but particularly Congress in this case, and even if you think about his own party, they would severely push against him. I mean, that's the hope, or at least the structural hope of our Constitution, that branches will contest each other, and there's no real, exact precedent, but there's competing dynamics working.
I think a lot of this is political, which is, I mean, why ultimately was Richard Nixon forced to resign? Because he would have been impeached. And why would he have been impeached? And we can only imagine convicted, because the Republicans were not going to stand up for him because he was seen as being too politically damaged. Yeah. And the firing of a special counsel who it seems, unless that person has engaged in some really serious wrongdoing, would just not be defended by the members of the president's own party. So it's just not worth it for presidents to do that. So it's not something I worry about. There's a lot I worry about with respect to the special counsel regulations. And as I say, I've got some ideas on how to improve the process. The firing of the special counsel is not part of what I worry about.
Thinking you're an originalist, obviously. How does the Constitution contemplate ultimately policing the executive branch? And also in the case of, I mean, this is obviously things that happen during a campaign, is the least the charge. And that's another interesting point we could discuss. No real crime has been alleged. Nothing specific anyway. It's just at this point, it's sort of innuendo almost, which I think also sort of sets this apart from past investigations. You might have a better historical sense than I do. But the Constitution, how does it contemplate policing this very powerful executive branch? Is it a matter of Congress finally stepping up and using its considerable powers?
Yes, so it's kind of interesting. We've got this problem here. What do you do about investigating the executive branch and dealing with government wrongdoing? And on the one hand, do you leave it to the executive branch to do it itself? That seems problematic. That seems inconsistent with the idea that one ought to be worried about wrongdoing by all entities, which is sort of the framers' approach to matters. On the other hand, do you deal with it by appointing some independent person who seems to be sort of outside of the political system, almost like a fourth branch of government? Did the framers really miss this? Did they not recognize that there was a problem here? No. They established a system of impeachment that would deal with this. There would be no conflict of interest in this, at least an institutional conflict of interest, in the sense that the House would investigate and find out if there was some wrongdoing, and then this would be tried by the Senate. So they set up a system with sort of, at least in their world and in general, better incentives, but with some very significant checks, especially the two-thirds requirement that the person who's being impeached can only be convicted by two-thirds of the Senate. So they set up a system that in a lot of ways makes much more sense than these independent counsel statutes. And some years ago, I wrote about this and trying to sort of reinvigorate that system. There's a lot of problems with at least in the modern world of using an impeachment process. The members of Congress typically don't want to engage in this kind of activity. They prefer someone else to do their work, just as they delegate lawmaking to the executive branch. They prefer to have some kind of counsel do the work so they don't have to be seen as being responsible. They're very partisan, so the investigations don't work very well. There's often not enough power or institutional ability within the Congress to do some of these things. So as we've got the modern Congress and its characteristics, the impeachment process has worked less well. And one really significant way of trying to deal with this problem of government wrongdoing might be to reinvigorate that in some ways. As I said, I had some proposals about 15 years ago. I'm not sure they work with this modern Congress, especially with all the political division that we have, but that's definitely one possible way to go. But that's the framers' way, that's for sure.
So it seems, though, too, in the modern context, one is the way we think about impeachment. And it seems, we're thinking about the Clinton impeachment, public discussion was all about, did he commit a high enough crime? And to me, there was always this idea that there's sort of a set of crimes that constitute impeachment. And Bill Clinton lying under oath, about sexual harassment or, sexual relations with his intern just didn't reach that standard. And the country said, yeah, that's right. But impeachment, in thinking about the use of it in the founders and, of course, how they would have inherited it from the English constitutional system, was far broader. And it wasn't about maybe even specific crimes. It was about constitutional inaction or not meeting your constitutional duties, as well as things that brought shame upon the office. And but that's sort of been lost. That seems one problem. Second problem to me just seems Congress is so its power and authority and abilities to investigate just seems structurally weaker now in relationship to the executive branch, even though the Constitution clearly gives Congress the ability to bring Washington to its heels if it wanted to.
Yeah, so the whole issue of what would constitute a high crime and misdemeanor was something that was greatly debated at the time of the Ken Starr investigation. And I think that there's different views about such matters, but I think in general it's thought that extended beyond simply crimes that are on the books. That lots of activities which were harmful to the United States in a serious way would be a high crime and misdemeanor. Some debate about whether or not the perjury or lying under oath, however one wants to think about what President Clinton might have done, fell into that category. But of course, there's a political side to all this as well. And as you said, a lot of people, President Clinton in a lot of ways was a very popular president. And I think that influenced people into thinking, well, he's a good president. This doesn't really go to the office, is what his defenders said. And so, this is not a serious enough matter to remove him from office. But the second part of your question, I've
Well, just thinking about Congress, it just seems
Congress,
thinking about, and I'm sure you watch these hearings too. Well, and I think about the IRS. To my knowledge, the IRS targeted Americans on the basis of political ideas and organizing principles, and tried to stop them from, granting them any legal recognition and 501c3 status. And there's been so political persecution is the other way to think about that. And no, there was no redress, no real penalties as far as I know of that were granted out to any official in the IRS. And in fact, we know the man appointed IRS commissioner in the wake of the one person who seemed to pay a price when he was appointed, John Koskinen, deliberately withheld evidence, and there's been nothing. And so you have to just take from that one episode Congress's relative inability to pursue executive branch wrongdoing.
Right. So it's an interesting question, sort of what happened during the Obama scandal.
The Obama, yeah.
President Obama said there were no scandals in his during his administration, but that doesn't really pass the laugh test. And so if we start with the IRS scandal, you're absolutely right. It's the inability of Congress to do anything effective in this matter is just puzzling, right? The impeachment of the commissioner is something that, to my mind, should have been pursued, if only just to have an investigation of the matter and to. Yeah. But Congress don't. They think about it obviously in terms of their, perhaps both in terms of the wider public interest, but in terms of how this is going to be viewed in their districts and their reelection chances, and they don't think it would be a favorable thing. On the other hand, the President Trump, who is willing to fire all kinds of people, they're not willing to fire the commissioner, where there's such strong evidence of wrongdoing. Very odd, I think, and it's not entirely clear, sort of it's not entirely clear what's going on, why it's so ineffective, but it clearly is ineffective. One really important aspect to this, though, I think, is the press. The press did what it could in a very significant way to minimize scandal. Yeah. And very quickly, opinion out there was, certainly among Democrats, but amongst moderates, was, this wasn't really a serious matter. And I'm not quite sure what led people to reach that conclusion, except for sort of this kind of press reporting. Contrast that with the press reporting of President Trump and the Trump campaign's connections with the Russians, and you've got something that's night and day, and that really matters a lot. And it ultimately matters to a lot of these members of Congress who, their constituents read the papers, see this, they're worried about being reelected and their reputations generally, and the press has a lot of power here. So I think one thing that really happened is the distinction between the way the press handled this. Now, it's an interesting thing, and if I may just go on for just a minute more. Well, one of the problems with the special counsel issue, with the special counsel as an institution, is that it's so unevenly applied. Why is it? I mean, even now you see relatively little discussion of this. Why is it that there was no special counsel appointed to investigate Hillary Clinton's emails? I mean, at the time when this was going on, I just would continue to ask this over and over again. Why is there no special counsel appointed here? This was someone who was going to take over the Democratic Party's candidate for president. There was clearly a conflict of interest with respect to the administration, the Department of Justice, and prosecuting or investigating Senator Clinton, and yet nothing was done. And by contrast, we've had this enormous grant of authority to investigate the Russian connections with the the Trump campaign, and there's a little bit, relatively small evidence of criminal wrongdoing in this area, at least as of yet. By contrast, we know James Comey himself said that there were criminal violations. It's very odd. If you had a working special counsel process, it seems to me that Hillary Clinton would have investigated, the Clinton Foundation would have been investigated, the IRS scandal would have been investigated. I wonder, and these things could be investigated now. It's a little interesting that the Trump administration has not appointed anybody. From a political perspective, it's interesting what that would have been. What about the unmaskings? One thing that the President Trump could do would be to appoint a special counsel looking into the unmaskings. At the very least, that would give attention to the matter. But they don't do these things, and there may be reasons not to do it. But what this sort of underscores is how the special counsel was only employed in certain limited circumstances. And I think that's a problem if we are interested in enforcing government wrongdoing, because I don't think you can trust the executive branch to engage in investigations of itself. Nobody wants a scandal within their administration. The party doesn't want a scandal within their party. It harms them, and so there's a strong tendency not to want to investigate.
Yeah, my answer with Obama is we really did see the principle play out of no enemies to the left, or no criticism to the left. There was a very much a unified group there. It seemed within the administration, and Eric Holder was willing, to my knowledge, to do anything needed to protect Barack Obama, and there was, as we've been discussing, incredible protection that he received through the press and through the chattering classes.
Yeah, the press was very supportive of President Obama. There was a great degree of Democratic unity as well. And I would say President Obama was a popular president, generally, especially as compared to other presidents in their second term. And as you say, President Trump is a very weak president in the first term, and I think that matters.
No, thinking here too. I mean, it seems with the special counsel investigation we're currently in, that there's been no real sense of a crime that's been committed. Nothing really has been alleged or pointed out. Nothing specific, and it seems just in general this is something that cuts against the entire framework. I mean, just a deep background moral commitment of our Constitution that you're not going to unleash a prosecutor on someone, no matter who it is, without a specific allegation, without a specific charge. And yet we have the Mueller investigation. We have other special counsels. That, to me, suggests right away we've deviated from the constitutional structure, which assumed something like politics, competition, self-interest would produce the best outcome, not these sort of quasi-frameworks, prosecutor operating in the executive branch, et cetera, et cetera.
Well, the appointment of a special counsel ends up being, in our world, and I think this is one of the reasons why I would want to see some changes, to be very much part of the political process. And the appointment of Robert Mueller was responsive to the politics of the situation and presumably the individual interests of the people who appointed him. And so this was, from a certain perspective, this was a way of getting the problem away from the Deputy Attorney General, right? Now, I don't want to, put motives in alleged motives where I can't be sure of the reasons. But one interesting thing is that Andy McCarthy at National Review and a former prosecutor himself has done a number of different pieces on why it is we ended up with such a broad mandate for Robert Mueller. And he's sort of pointed out that there's a distinction between a criminal investigation and a counterintelligence investigation. A criminal investigation is focused in on wrongdoing, criminal wrongdoing by an individual, whether laws were broken. A counterintelligence investigation is much more about whether a foreign government was engaged in activities in the United States and to harm the country. And the investigation that was originally occurring that Comey was pursuing was a counterintelligence investigation, which is a very different kind of a thing. And what McCarthy points out is what Rosenstein did was to take that counterintelligence investigation, which is not about criminal wrongdoing. I mean, you could, when engaged in a counterintelligence investigation, you can sometimes find criminal wrongdoing, and then you can create a criminal investigation. But in general, is not about finding criminal wrongdoing. Took that jurisdiction and then gave it to Robert Mueller, not to engage in a counterintelligence investigation, but a criminal investigation. Yeah. And according to McCarthy, and I find the argument, quite interesting one, that's the reason why we have, or at least part of the reason why we have such a broad mandate. Obviously, the politics of the situation is also important.
Yeah, well, McCarthy also argued Jeff Sessions should not have recused himself.
Based on exactly the same kind of argument, that the recusal involved the recusal statute or regulation involved a matter where there was a criminal investigation.
I suppose the counterintelligence investigation could easily flip, and somebody would have to make the decision that it's now a criminal investigation, and so Sessions was right to recuse himself because he would have to have made that determination, I think.
Well, the Wall Street Journal said that Sessions was right to do that because it could turn into a criminal investigation, and McCarthy responds and says, well, this is an extremely broad area. If it turns into a criminal investigation, then you recuse yourself at that time. So, according to McCarthy, there are certain portions of the investigation now that maybe reach the level where you ought to have a criminal investigation. He says the false statements investigation of Flynn, the obstruction investigation of Trump, those are specific enough. There's maybe evidence, according to McCarthy, of criminal wrongdoing enough so that you would have a criminal investigation. That would, if that was all Mueller was authorized to look into, that would be far, far narrower than the extremely broad area where he has been authorized.
Okay, so Mike, thinking here, you have also written about ways to reform the special counsel process, and just thinking about this issue where a special counsel will spend a lot of money and a lot of time pursuing an investigation. There's going to be public drama about this, and there's almost an incentive, a very strong incentive, to get someone, even if it's Scooter Libby, who inadvertently disclosed something not even really germane to the original investigation. He ends up going to jail and losing his bar license. Something like that can easily happen. So thinking about those outcomes, which doesn't seem to be optimal, you've talked about having a two-part special counsel. Maybe elaborate on that.
Right. So I think right now the special counsel investigations suffer from several different infirmities. I think there's actually 4 of them, but the biggest one is the one that you're averting to here, which is that the incentives of the special counsel. If you think about it, you're Robert Mueller. You're looking into these matters. You could come to the conclusion that no wrongdoing occurred, or not enough wrongdoing occurred to justify a criminal investigation, and you're done. And you're out of, that's the end of the matter. A lot of people are going to strongly criticize you. On the other hand, what you can do is decide that wrongdoing has occurred, and then you remain in the limelight for a long period of time. and there's a real possibility that you bring home a very big fish, that you convict a big fish. So there are real incentives here on the part of the special counsel. I'm not trying to cast aspersions on anyone's integrity, but we do know people respond to incentives, and there's real incentives to just continue to prosecute rather than to not prosecute, and that's a real problem. And it's such a serious problem that if we couldn't do anything about it, I'm not sure. I'd all be able to recommend anything with respect to the special counsel. But what I think we ought to do is have a two-stage process here. And so what would happen is you would have one person, let's call it Robert Mueller 1, who'd be looking into the matter and would conclude, okay, either no prosecution should occur or a prosecution should occur in this limited area. And once they make that decision, the prosecution would then, if they've authorized the prosecution, would then be conducted by someone entirely separate. And in that way, we wouldn't have the person who's actually doing the prosecuting making the decision, and they wouldn't have an incentive to want to prosecute in order to keep themselves in the limelight. In fact, in some ways, their reputation would be enhanced if they were to say, no, I don't think there's any wrongdoing that's occurred here. People would say, this was a person, look what integrity they had. Now, obviously, some people would not be happy about it. But we would at least deal with this incentive that special prosecutors have to prosecute people in order to remain in the limelight and to justify their importance.
Yeah, no, I mean, you could see. I like that idea. I mean, I guess the question would be, who's the second guy or woman to bring the charges or to bring them to completion? That's a whole separate level of drama, I suppose. Who gets picked? Or, I suppose you pick them from the outset, but then, how does politics then influence their own decision in deciding what to do, particularly in the case of someone like, think about Bill Clinton, where the public had seemed to be so strongly turned against Ken Starr. I suppose that would have been its own interesting case. Thinking too.
I actually think
Go ahead.
No. The second part of the process, where the person actually prosecutes, in a way, is less politically important, because once you've got a prosecution authorized, then go ahead and prosecute, and prosecutors are going to be similar in that. They all don't behave exactly the same way. The real tough judgment aspects are going to be from the first person who has to decide whether or not they're going to authorize the prosecution or not.
Yeah, okay. Oh, well, that's interesting. So your thoughts, I mean, overall, I mean, it's been thinking about this set of Russia, the questions over Russia and Trump. Is it, I mean, you have to wonder too, if we're just in a situation now where there's no real way outside of politics, I think, for these investigations to occur, it seems, in the current environment in Washington. And, really what we actually need, and this comes back to a theme that's been a part of the interview, we actually need a separation of power system and a Congress across the board to just be Congress again, to make Congress great again in pursuing not only these investigations, but also its duties of making law, of tax powers, of ensuring that, that there's actually a representative branch that's not anemic. It seems to me that is the best way to deal with what's going on right now. But of course, that's a hard call. That's a hard thing to see happen.
Yes, I completely agree that a stronger Congress would solve many of our problems. We if you step back and you look, what are we talking about here? We're talking about investigation of wrongdoing, and of course the system set up by the framers is one where Congress would do this, but Congress doesn't want to do this and is not very good at doing it. You look at the parallel area of passing laws and regulations. Yeah. Right. And what has happened? Congress doesn't do this any longer. It delegates to the executive branch to pass these regulations. And I think there are all kinds of problems that arise as a result of Congress making those delegations. We've got far more political division as a result of that. And so many of our infirmities I see as actually the result of the fact that we don't have the Congress acting and through the sort of, processes that the Constitution has established. And this is just, again, another example of it. And sadly, largely due to the fact that Congress doesn't want the responsibility here. And that our institutions have allowed Congress to pass this off, saying, Congress can give away power. No, the Constitution requires someone to exercise power, and they're giving it away is a way of undermining the constitutional system. And some Supreme Court cases don't really seem to recognize that point.
Taking themselves off the hook and removing themselves from accountability. Michael Rappaport, thank you so much for your time, for talking about the Mueller investigation, constitutional questions around policing the executive branch. So this has been a great discussion. I appreciate it so much. Thank you.
Thank you, Richard. I enjoyed it.
This is your host, Richard Greinch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.